Yo, doing this government project at Thatcher's house, just swiped his iPad, about to take this piece to the pawn shop. Later.
You trying to run away with my iPod? Not gonna happen. Oh, just stole. He tried to steal my iPad, but guess what? The Second Amendment says that I can have a gun so I can defend myself and kill Holmes. Sorry about it, man.
Right, here today I'm talking about the Ninth Amendment and two court cases that relate to the Ninth Amendment. The Ninth Amendment in the Constitution is stated as, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Well, there are two court cases. Einstadt v. Baird, which was a court case dealing with criminalization of contraceptives used by unmarried couples, which was considered illegal by the Supreme Court on a 6-1 decision because that violated the marital privacy rights of these couples. This was significant because the ruling recognized the rights of single people to procreate on the same basis as married couples, which was not immediately taken as a logical conclusion because this was back before sex before marriage was a known thing. The reasoning behind this court case, this decision, was the court upheld both Baird's standings to appeal and the First Circuit's decision on the basis of the Equal Protection Clause, but did not reach the due process issue. The majority opinion, written by Chief Justice William Brennan, adjourned by Douglas Stewart and Thurgood Marshall, reasoned that Massachusetts did not enforce its laws against married couples, and therefore, under Griswold v. Connecticut, the law worked irrationally discriminating against unmarried couples. Now, pertaining to that, Griswold v. Connecticut is the other case I would like to talk about today. It was a Connecticut law criminalizing the use of contraceptives that also violated the rights of marital privacy, but this was before Einstadt v. Baird. The reasoning was that since Griswold, who sued against Connecticut, Supreme Court cited that he had the right to privacy in several rulings, most notably originally in Roe v. Wade, where the court ruled that a woman's choice to have an abortion was protected as a private decision between her and her doctor. For the most part, the court had made these later rulings on the basis of Judge Harlan's substance due process rationale. So these two court cases, along with the Ninth Amendment, help protect a person's basic privacy with other amendments in the Bill of Rights.
Bobby, Holmes Allhorn. Could you delve in a little deeper into the original wording of the Ninth Amendment and how that might be interpreted in modern-day English and the meaning behind it?
Yes, of course, Holmes. Well, as stated in the Constitution, as previously stated, the Ninth Amendment is read as the enumeration in the Constitution of certain rights shall not be constructed to deny or disparage others retained by the people. Well, this has been construed in a multitude of ways and is one of the most thought about amendments in the Constitution by scholars. The Supreme Court has had multiple problems with this, but the main reason they only cite the Ninth Amendment is for a right of privacy, which works along with other amendments such as the Third, Fourth, and Sixth Amendment.
Thank you.
Yes.
Hello, class. My name is Thatcher Jennings, and today I'm going to be teaching you all a little bit about a couple court cases that have to do with the Second Amendment, which is part of our group project for government. I believe there's an interviewer here who wants to ask me a few questions, so feel free to begin.
Yes, Thatcher. Holmes Allhorn here. What is the name of the case that you're talking about right now?
Well, I'm going to be talking about two cases, but the first one that I want to address is Presser versus the state of Illinois.
All right. What year was this case held in?
This case was held in 1886. It was a long time ago, Holmes.
Well, that is a long time ago, Thatcher. What happened to bring this case to the Supreme Court?
Well, there was a lot of stuff that happened, but basically, this guy, Presser, he was with a bunch of people. He was basically at the head of about 400 people who were marching through, the city of Chicago, and they were all armed, or most of them were armed. Presser, in general, had a big old sword that he could, stab people with. It was called a cavalry sword. But apart from that, 400 of his men had guns, and they were pretty much ready to kill people. They were actually protesting something.
All right. Well, what was the argument that this group brought in front of the Supreme Court?
Well, see, the state of Chicago believed that they had no right to be parading through the city of Chicago because they didn't have a license. They actually said that they were not regular organized volunteer militia of the state of Illinois, or troops of the United States. So therefore, they have to have a specific license to, I believe it's the First Amendment, but to assemble and petition as a group. And I guess they didn't have that license, Holmes.
That's quite a shame, Thatcher.
Yeah, but so basically, Presser, in December of 1879, he marched through the city of Chicago with 400 people and protested. And then the governor of Illinois stated that the company that he was controlling, his 400 people, said that they were doing illegal things, and Presser said that the law that they had to get a license to march violated the rights of his Second Amendment to bear arms.
So in lieu of all this, what was the Supreme Court's final verdict?
Well, I'll tell you that in just a second. Pause. Welcome back. To answer Holmes's most recent question, the Supreme Court stated, and I quote, "We think it clear that the sections under consideration, which only forbid bodies of men to associate together as military organizations, or to drill or parade with arms in cities and towns, unless authorized by law, do not infringe the right of people to keep and bear arms. But a conclusive answer to the contention that this amendment prohibits the legislation in question lies in the fact that the amendment is a limitation only upon the power of Congress and the national government, and not that of the state." Now, in Presser, the court reaffirmed the Cruikshank decision, which is the other case that I'm going to talk about, that the Second Amendment acts as a limitation only on the federal government and not the states. Now, Cruikshank and Presser are consistently used by the lower courts to deny any recognition of individual rights and claims, and provides justification to state and local governments to pass laws that regulate guns. However, the High Court also stated that there is a limit upon state restriction of firearm ownership, and that they may not disarm the people to such an extent that there is no remaining armed militia force for the general government to call upon. So that's what the Supreme Court said about Presser versus Illinois. Basically, it said that the Bill of Rights, which includes the Second Amendment, applies not only to the federal government, but also to the states.
Thank you very much, Thatcher. Thank you for your time.
No, Holmes. Thank you.
Hello, class. Holmes Allhorn here. Today I'll be talking to you about D.C. versus Heller. This case presents one of, if not the most important Second Amendment precedent in the 21st century. I believe we have an interviewer here today, Thatcher Jennings.
Yes, we do, Holmes. Thanks for introducing me. So I'm just going to ask you a few questions about D.C. versus Heller. Firstly, what happened to bring this case to the Supreme Court? Like, why is it where it is today?
Well, the District of Columbia began passing some very, very strict legislation on the registration of handguns, and they also required a license for all pistols to be owned, and they mandated that all firearms kept by a person in their home must be kept unloaded and disassembled or with their trigger locked. So, some people in the District of Columbia did not take too kindly to this and brought this case to appeals court. Federal trial court.
You're excused.
Yes, thank you. And the federal trials court stated that the Second Amendment, as stated in the Constitution, only applies to militias. So then, these plaintiffs collectively didn't take too kindly to this, took this case to the appeals court, and the appeals court sided with the plaintiffs, saying that the Second Amendment does not only apply to militias, but
Excuse the dog. I'm sorry. He's a little rascal.
He's nice. Sorry. Applies to private owners and citizens as well as militias. So then, this case finds its way to the Supreme Court because of petitioners that agreed with the original trial's court decision.
I see. That's very interesting. So you may have stated what the exact argument was, what both sides were thinking, but could you just restate that, how they argued it in front of the Supreme Court, if possible?
Well, the counter-argument was, that the Second Amendment need not apply to the District of Columbia. As most of you know, the District of Columbia is not, in fact, a state.
Right.
And also, in the legislation proposed, prohibiting handguns and the unloading and disassembling of your guns. They argue that merely prohibits gun use. It doesn't infringe upon their right to bear arms. And obviously the plaintiffs disagreed and took this to the Supreme Court, arguing that this does, in fact, infringe upon their right to bear arms.
Okay. So what was the Supreme Court's final verdict? And Nike, if you could just go away.
In the final decision, the Supreme Court ruled in a 5-4 ruling that the Washington, D.C. legislation does, in fact, infringe upon the citizens' right to bear arms. They based their ruling on, obviously, the right to bear arms, and as well as some language in state constitutions that were adopted just after the Second Amendment. And now there are no more heinous, restrictive legislations being placed on handgun owners in the District of Columbia.
Well, thank you, Holmes, for all that information. I look forward to speaking with you again soon.
Thank you for your time.